Hi, my name is Bobby Fazy. I'm president of Insight Law, and I'm an estate planning attorney. If you're listening to this video, then you've been named a helper or you're a client in the Insight Law Maintenance and Education Program. We've done estate planning for you as a client, and this program, the purpose of this program is really to get you comfortable with your planning, or if you're a helper in a friend or your family's planning, to prepare you if there is a disability in the family. In my family, there was a disability that occurred with my father. He was diagnosed with Alzheimer's, and we as a family were not prepared. And our mission at Insight Law is to create a plan that works for our families, for our client families, and this program is really geared towards making you comfortable for the planning. So let's jump into the program. The title of it is called What to Do When a Loved One is Ill. The first, or the main overriding goals for this program, is to familiarize you with the disability process, what we're doing on the legal side of things so that you understand, and what your role is in the process as well. That will hopefully give you peace of mind and build you confidence in the process, and to prepare you for issues that you will likely face. The last thing I want is that something happens to a friend or your family, that there's a disability, and then you have no education on what legal issues there are, financial issues, and then you're put in a reactive position. So we're all about being proactive so that you're comfortable with the planning. Okay, so nuts and bolts types of items that were the goals for this program is to provide you with an overview of the tasks to be performed if a disability occurs, to encourage you to be proactive, to motivate you to get your loved ones involved, and to help you prepare, to let you know how you can help the client better prepare for a disability situation. Okay. Another goal, or the big basic steps for the goals, are to know the law firm and our contact information. That's a very big, it's a simple step, but it's important to know. Remember, there's a process, and we'll show you our process so that you understand it, and we find that the process produces predictable results and the process works. We've done this before. And then give you an idea of the types of issues that you will deal with in the disability process, and encourage interest in planning participation. So with that being said, I'll give you some logistics. If you are watching this program and you're listening to it and you have a question, and you're listening to this through a webinar, what we're going to ask you to do at the end of the program, if you're listening to this off-site and you're a helper, we're going to ask you to take a short quiz so that we make sure that you listen to the video. And again, the purpose is to make you comfortable with the planning, to make sure that the plan works, and make sure that you had listened to it so that we feel confident that you will understand the issues. Now, if you have a question about something that was presented in the video, or you want to contact our firm, the contact information is, you can contact our office at 703-654-6019, or you can email me directly at raf@insightlaw.net. Our website, by the way, is www.insightlaw.net, and if you are not a client, you're a helper, our generic username and login is Insight Law is the username, and then password is client, all lowercase. On the website, you'll find some resources and tools and videos like this that can help make you comfortable with the planning. The presentation is divided up into two separate parts. The first part is we're going to deal with just disability, and then we'll have a separate video that deals with when a loved one passes away and the steps that we take as a law firm and that you should be familiar with. So as far as the disability is concerned, you need to make sure that you understand some of the resources that we provide. One of the main resources, if you're listening to this video and you're a helper or you're a client, is our Helper's Handbook. And the Helper's Handbook, the purpose of this Helper's Handbook is to give you a nice, simple resource guide that if something does happen in the situation, a family member, friend is disabled, that you have a resource that you can go to. And we ask that you attend this program at least once every 5 years. We'll note the dates in the back of the book. We'll send you a book if you are listening to this from a different location. We'll update it at every 5 years when we go ahead and go through the planning. Couple other ideas or a couple other tools that we use at the law firm so that you're familiar with them is the red books that we use at our law firm. That's where the legal instructions are, the legal documents that we have that we work with our clients. Things like trusts, wills, powers of attorneys, medical directives, all the legal instructions are located in the red book. We also have at our firm, we use what's called a Insight Law Client Organizer or a Client Operator's Manual, and these are really where how to work with the firm, instructions, checklists that we have, how to communicate with the firm. So the red book has the legal instructions, the white book is more of the checklist and how to work with the firm, and then the helper's handbook is really geared towards this program and what to do when a loved one passes away program on our steps that we take. So, as a helper and also as a client, you need to know, you have to put these books in a safe place, but know where they're at. They don't need to go into a safe deposit box or anything like that, but they should be in a location where your helpers can reach them and locate them if there is a disability or death, because the helpers will need access to these books. There's also an extra copy always at the law firm if those can't be located. So the red book contains your revocable living trust, and for those of you who aren't familiar with the trust is really the hub of your estate plan. Some people will call it a will substitute, but if the trust is done properly, it really lays out all of your instructions, and it contains many personalized provisions and a lot of protections that we can build into the plan for our clients. So how a trust works is, think of a trust as nothing more than a box. And on the outside of the box, we can have a lot of instructions if there's a disability, if there's a death, how things get transferred, and how to protect assets. Those instructions will only apply to those assets that are actually in the box for the most part. So what we do with the trust is we will put bank accounts into a trust. We will put investment accounts into a trust. We will put real estate into the trust. And what happens is the trustees of the trust will be able to manage those assets. Some items we don't put in a trust, and that's state specific, or there's specific federal laws. But for the most part, we put most of the assets in the trust. But for example, in Virginia, we don't put automobiles in a trust. There's a specific way that we can transfer those items outside of the trust and avoid the court process. Also, we would never put IRAs or qualified plans into the trust, but we actually look at the beneficiary designations on those. We'll get more to that later in the program, but just think of the trust as a box, and we put a lot of the assets into it, and the trustees of the trust are able to manage those assets. So, in the trust, Article 4, Section 2 of the trust defines disability, and we're talking about a mental disability, not a physical disability. And the way that we define it at the law firm is that I shall be deemed disabled during any period when, in the opinion of my disability panel, I am incapacitated or disabled because of illness, age, or any other cause which results in my inability to effectively manage my property or financial affairs. So at the point when you cannot no longer manage your financial affairs, and that's the standard, then we have to look at disability a little bit closer. Okay, now let's get into the actual steps that we follow when there is a potential disability. Number one, we can't know about a client's disability normally before the family does, so please notify the law firm. The earlier that you notify us, the more legal options we can present to you. So that's step number one, is stop and call the law firm. Number two is we'll do our own due diligence on our side to make sure that there's a disability that rises to a level that it would necessitate us stepping in and invoking our process. Step three is we will then call what's called a disability panel conference or disability conference. otherwise known as a personal counseling review or a family counseling review, where we'll bring in the various players, and those players would be disability panel members. Now, the disability panel members have been named in the trust book in Article 4. Our clients have entrusted you to make the decision whether the client is able to manage their affairs or not. So there's no healthcare decision-making authority. They're just trying to decide if there is a mental disability. Step number 4 is the disability panel members will then be the ones who will do their own due diligence. They'll either talk to doctors, interview neighbors, talk to the client to determine if that does rise to a level whether it could be a mental disability. If in fact there is a mental disability, then the disability panel members will sign what's called a disability certificate, and that's going to be signed also by the doctors as well. And then the next step after that is we're going to identify who all the disability trustees are. So a trustee, to give you a quick summary or synopsis of how a trust works, is there'll be a trust maker, the one who created the trust, and then you'll have a trustee, the person who manages the trust, and then a beneficiary. So initially, the clients are going to basically fill most of those roles as the trust maker, the trustee, and the beneficiary. But when they're no longer able to manage their financial affairs, then we have to have a successor trustee to be able to handle that. Our goal is to keep things private, keep the courts out of it, and have an orderly process for that. So we'd identify those people who would be the successor trustees to manage those assets, and they serve subject to the priorities and instructions laid out in the trust. But again, they have no healthcare decision-making authority. The trustees deal solely with the finances. Step 7 is the disability trustees will sign what's called a disability certification of trust. That will give them legal authority to manage the assets in the trust. On the attorney side, we'll sign a certification of attorney certification. And then step 9 is we want to locate all of the financial assets so that we know where things are located and to make sure that the trustees can manage those assets. We have what's called, if our clients are on our maintenance plan, every year we produce a report called an asset review report. So that should be very easy for us to find. Once we determined there is a disability, the asset review report is also located in our client organizers. The client's reports are there as well. Those asset review reports are updated each year, and so there's no more than 12 months out of date. So that should give us a really good list of the assets and make our jobs a lot easier. Step 10 is complete the asset transfer paperwork. Asset transfer paperwork is the paperwork from the different financial institutions that they'll have. If you have bank accounts, investment accounts, those types of assets, they have specific paperwork that we'll prepare. And then step 11 is we'll deliver that paperwork to the various financial custodians, and then we will verify change of ownership or change of the trusteeship for those assets. And then as the trustees, the successor trustees, if you have been listed as a successor trustee, you have to manage those assets as a fiduciary for the trust maker. You're looking out for them. And if there's a disability, you want to make sure that whatever healthcare instructions that they've laid out as far as on the financial side, if they do want to live at home, that the money is being used for that purpose or for the client or for the family situation. And then you want to coordinate the finances with the healthcare agents. So there's a couple different roles. The healthcare agents are the ones who have the decision to make or the authority to make healthcare decisions, such as check the client into a hospital or keep the client at home and to have home care taken there. So you need to be on the same page. You may fill all those roles as a trustee or a healthcare agent, but not necessarily. They should be coordinated. Potential obstacles in the disability planning process is that assets that are not owned in the trust. So we just said that with the trust, we have trustees that manage those assets, and we have a very smooth, specific process to manage the flow or control of those assets in a disability situation. But what if those assets aren't located in the trust? So some assets we are not put into the trust. The reason why, there's a couple reasons why. Number one reason why, or one of the reasons why that's very frustrating to the firm, is that some of the assets were not reported to the firm, and therefore they're not into the trust. So it's really important that we're getting full disclosure, and you as a helper can make sure that the assets are titled, that we have a complete list of the assets, because just one asset not being titled properly can really frustrate the plan. But if there is a disability, and then we do determine that there isn't an asset that's supposed to be in the trust, that's not actually in the trust, we have created what's called a funding power of attorney, which will allow the agent to transfer assets to the trust. Again, this is not the preferred method, but it is a legal document that is located in the Red Book that would enable us to manage those assets or to transfer those assets to the trust in that type of situation. But some assets cannot be owned by a trust, so you want to make sure that you understand which assets can and cannot be. I alluded to it earlier, but qualified retirement plans, for example, those would be IRAs, 401ks, 403bs, TSP plans. Those assets we do not put into a trust. Those are considered qualified assets that are usually tax sheltered, and if we would change the names on all those assets, then the IRS would consider that to be a distribution. That's when taxes are due, and that's the last thing that I would want to do, is cause unnecessary taxes for your family. So we do not put those assets inside of the trust, but they still may need to be managed. IRA, we might need to take IRA distributions, or we need to have, they need to be, asset allocations might need to be changed during that type of period. Also, another type of asset that we don't put into a trust normally are annuities. Annuities are contracts. They're controlled by the beneficiary designations, and they're very specific designations that we would look at. So we don't normally put an annuity inside of a trust. So they still may need to be managed, and so that you know the different roles. The way that we are able to manage those assets that are not in the trust, like qualified plans and annuities, is through what's called a durable general power of attorney. And our clients have signed those durable general power of attorney, and if you're the trustee of the trust in a disability situation, then you are usually the agent under the power of attorney. Same authority as far as managing financial assets, but it's a different document that we use. And we give that document to the financial institution so that you're able to manage those assets. Okay, I went through the financial side of it before. Now let's look at the healthcare questions and the healthcare issues and the legal documents associated with it. So normally we use for healthcare decision making what's called an advanced medical directive. An advanced medical directive has a couple of roles. Number one, it designates your healthcare agent to make healthcare decisions for you only if you're not able to make them for yourself. So only when you're unable to communicate with the doctor, then does that healthcare power of attorney or advanced medical directive kick in. It gives someone else the power to make healthcare decisions for you, and it also has the second role of communicating your end stage life wishes. So it's that living will component. So one is making all those decisions up to that end life stage decision, and then if you were on life support and persistent vegetative state and no likelihood of recovering, we call it no heroic measures. What are your wishes? And most of our clients have opted for their constitutional right of not being kept alive artificially, but those instructions are laid out in the advanced medical directive. It really takes the burden off the loved one once we communicated those wishes. And we also have the other legal documents that we use is what's called a HIPAA release. That's the legal document that you give to the doctors to make that they like, and that it states that you're not going to sue them for disclosing their healthcare information, their client's healthcare information to the healthcare agent. And then some of our clients have opted to be organ donors, and we have an anatomical gift form as well. The biggest issue that I find when it comes to disability planning, and it was really hit home in our family's planning, is the actual instructions. So the Advanced Medical Directive is a legal document that will say, it'll give a list of powers and it's authorized by statute. But digging deeper underneath that and trying to put the healthcare agent in the client's position is what we're trying to get to. And there's no way that you can guess every, what the client would have wanted in every situation. But we've created checklists and letters of instructions that we have our clients complete that really take the pressure off and help the healthcare agent understand what the client would want in different scenarios. So it's really important that our clients complete this, and as helpers and as clients, if you're listening to this, if the helper's handbook that has been provided to you, if there are not checklists in there that have been completed, we urge you to get those completed or contact the client to ask them if they have completed them, so that we make sure that we get them. So that's one of, hopefully we'll be able to get that 100% complete soon. So those healthcare instructions really are a great tool. They're also located in the white Insight Law client organizers that the clients have. But you as a helper, that they would be located in the helper's handbook if we do have these documents completed. Other document or other service that we use is called DaKey Bank. And DaKey Bank is a service where the client will actually get a credit card that has contact information and instructions to actually pull the medical directives and checklists, and they're stored digitally online. So it's a service that we use where the client's healthcare directives, healthcare instructions, letters of instructions are actually scanned and put on the DaKey Bank server, and there's access to it 365 days a year, 24 hours a day. The main thing is that the client actually presents that DaKey Bank card to the healthcare provider, or that you as a helper have access to the DaKey Bank system. Patients can log in online and send email copies to helpers, so you can actually get an email copy of the DaKey Bank card. So I would encourage you to ask the clients to do that for you. So, as a summary, as far as the disability procedures on the healthcare decision making, we want to provide copies of advanced medical directives and HIPAA releases to medical care providers. Follow the instructions in the healthcare checklist. Coordinate with the disability trustee who handles the financial aspects, and also check for long-term care insurance policies and disability insurance policies. The law firm may be able to assist in that area as well, because those policies actually provide funding in a lot of these situations. Helper roles. Let me make sure that we give a summary on the helper roles so that you know who does what. The disability panel, those the participants decide only whether you are disabled or not. Healthcare representatives or healthcare agents only decide on healthcare decisions. Disability trustees handle the assets, the financial side of things, and then agents under a power of attorney will handle the financial assets or the financial decisions for those assets that are held outside of the trust. A lot of times we'll get calls, clients are saying that mom is disabled, where's the power of attorney, because we need to manage the bank account. But if we've done all things, if everything is done according to our process, those bank accounts are in a trust, and the trustees of the trust will handle it. Powers of attorney would not be necessary for those assets. Proactive lifetime steps that you can take. Number one, fully fund the trust. Our funding coordinator, Wendy Masomer, every year is looking through the files, reviewing the files to get 100% funding on the trust assets. So it's really important that you work with her to get those assets titled properly, because it really makes the planning go smoother in the event of a disability or death. Number two, communicate the what to do steps now. So listening to this video is a very big first step in getting comfortable and knowing what the law firm does, and then your role as well. Number three is complete the location lists. We have location lists that are in the red binders that say, where the different financial assets are, or the statements for the different assets, password locations, just to make managing of the assets more efficient. And then also keep the law firm helper beneficiary info current at all times. So if you change your helpers, let us know, or if their addresses change. The whole goal of our program is to make the plan work and to make it seamless. So if we don't have to go tracking people down, then it makes our lives a lot easier. Proactive lifetime steps continued is consolidate investments. If we have to go to 4, 5, 6 different financial institutions, it just takes that much more time. Consolidating investments in 1 or 2 locations makes the administrative side a lot easier. Attack clutter now, be proactive, get organized. Complete your personalized healthcare instructions and the letters of instructions to your healthcare agents. Review DaKey Bank use. There's a DaKey Bank video that there's a link on our website that goes over the services of DaKey Bank. Feel free to go ahead and use that. And then also set up a family listserv if you're interested. That way, if there's a disability, we've got all the people, and it's a nice, efficient way of managing information and communication with the clients. So if you're not familiar with what a listserv is, it's basically an email group of individuals. So we would list maybe mom and dad, kids, all on the same email send side of things, and that way we could all communicate and be on the same page. Again, call a firm with any questions. There's no additional charge if you're on the Insight Law Maintenance Plan for questions, or not charged for phone calls. Our goal, again, is to make sure that the plan works. That concludes the first half of the trustee training program, What to Do When a Loved One Becomes Disabled. I hope that has been helpful for you. Remember, if you are a helper and you're not local, have not come to the event, we're going to ask you to take a short quiz and complete that quiz and return that to the law firm. Thank you very much.